Hi everyone, good evening and welcome to Thorough Newspaper Analysis. This is the video for the 1st of June 2024, and with this today we entered into the new month for the year 2024, and I really hope that it proves absolutely productive for all of us and we have a wonderful year learning wise ahead. A wonderful month. So now let's proceed and have a look at the pointers of discussion for the day. Now today we'll solely be confined to the editorial segment, and today's article is more in the nature of a fact repository of, let's say, what are the safety regulations in India so far as fire accidents are concerned. So this article is taken from the Hindu, and now let's proceed with the article. So first of all, we'll have a look at two unfortunate accidents that happened on 25th of May this year, wherein fire broke in certain premises, and as a result, it led to fatalities and death of 32 accidents, 32 lives. In case of Gujarat accident, while in case of Delhi accident, it claimed lives of 7 newborn kids, babies. So now let's have a look at the context quickly. So a deadly fire, it broke at a gaming center. This happened in Rajkot in Gujarat on 25th of May. It killed at least 32 people, bringing focus back on the safety of public buildings and venues. The TRP game zone carnage, it unfolded in the evening as fire spread inside the structure, which was built with metal frame and sheets, thereby trapping the victims, including several children. As a result of this unfortunate accident, two inquiries have been set up to investigate into this disaster. One is an SIT, which is a special investigation team. It is set up by the state government and another by the Rajkot police. Also, what is appreciable here is the fact that the Gujarat High Court has taken so much cognizance of this entire matter. That is to say, this Gujarat High Court has come on its own motion to look into this case and made critical observations on the functioning of the state administration. And as a result of this action of the High Court, the state administration got into action, and as a result, the police commissioner, the additional commissioner, and also the municipal commissioner, they were transferred. Apart from this, Rajkot municipal officials, including the town planning officers who were responsible for the prevention of illegal constructions, they were also suspended, along with the arrest of 4 people, including the operator of the game zone. Similarly, there was another accident of fire, which happened in Vivek Vihar, Delhi. This happened on the same day where 7 babies died in a fire in a hospital for newborns. This led to the arrest of the owner of the newborn baby care hospital along with the doctor who was on duty. Now, here we have to take note of this one fact. Preliminary assessment was done and the reports are out. And as per those reports, it suggested that a large number of oxygen cylinders which were stored in the facility, it aggravated the impact of this fire. In both the incidents, the focus is on fire certification by the authorities, the issue of non-objection certificates, and the failure of authorities to take cognizance of illegalities that were happening in full public view. Now let's talk about what fire regulations govern safety. Now that we've talked about these accidents and also had a look at the fact that because there were lapses in the issuance of no objection certificate and the compromise that was made in following the fire safety norms in the structural design of the buildings, and these were very taken very casually by the authorities who were supposed to take care of the situation at the outset itself. So having said that, let's understand what are the fire regulations in place. Please understand the Union of India's position on fire safety. It is that the Model Building Bylaws 2016 and its component, especially Chapter 2 on fire protection and fire safety requirements, it provides the necessary framework for state governments which bear responsibility for the fire safety under law. Ensuring adherence to fire safety norms and standards laid down in Part 4 of the National Building Code and the incorporating mandatory provisions in the process, it is left to the state. So it is the onus or the obligation to enforce these safety norms is upon the state. A structure such as the Rajkot Game Zone, it would fall under assembly buildings. Now, what is an assembly building? That we'll understand later. So it falls under the category of essential, it would fall under the category of essential buildings under the bylaws, since it is a venue without permanent sitting arrangements where 300 or more persons would gather. The definition of assembly buildings, it is broad under the regulations. So let's see what is an assembly building. These sort of buildings, they are buildings where not less than 50. So minimum 50 people, they gather for the purposes of amusement, recreation, or there's a social, religious, patriotic, civil, travel, and similar purposes. So for example, we have the movie theaters, motion picture houses, assembly halls, museums, there's gymnasiums, restaurant, places of worship, dance halls, clubs, club rooms, then there's passenger stations and terminals of air, surface, and marine public transportation services, recreation piers, and stadia. So all of these are, buildings which can come into the category of what is called an assembly building. And the criteria here is that, at least minimum 50 people can gather here. So this is a 50 people minimum capacity holding, and it is mostly for the purpose of leisure activities. Hospitals, custodial and penal or mental health institutions, they are institutional buildings, while when it comes to educational, business, industry, and specialized uses, they are covered separately. So far we have seen three sort of structures under the bylaws. First is the assembly building. Then secondly, we have the hospitals and buildings of the like nature, which are called institutional buildings. And then apart from that, educational and other buildings, they are covered separately. During the COVID-19 pandemic, amidst the spat of fires, the Health Ministry circulated certain guidelines. These guidelines came about in September of 2020, whereby it was stipulated third-party accreditation for fire safety and putting a fire response plan in place. So those guidelines proposed and stipulated that there should be accreditation for fire safety by third-party agency. Chapter 2 of the bylaws clearly lays down fire safety and infrastructure requirements for buildings which are 49 feet in height or more, and those with low occupancies in various categories for issue of an NOC certificate. In addition, Gujarat's Comprehensive Development Control Regulations 2017 also make it mandatory to get the Chief Fire Officer's opinion even for a temporary structure. The same regulations stipulate that all structures for whatever use, they must meet fire prevention and safety provisions specified by the Fire Authority in terms of the Fire Prevention and Life Safety Measures Act 2030. In the case of the game zone accident, it was built apparently as a non-standard structure to evade regulatory requirements. See, this is the problem. With a lot of these buildings, no, they do not follow the regulatory provisions, and in fact, they try to flout and try to avoid getting the regulatory compulsory work done. And as a result, they continue operating, and it takes an unfortunate accident like this to bring our attention to the fact that these safety norms are indeed absolutely essential, and they must be adhered to at any at every cost. So there should not be such building owners who are just flouting these safety measures and are accommodating people. They are essentially inviting people to have good time, to just enjoy leisure and have fun game zone activities, by knowing the fact that their building, it is not adherent to the safety norms. So this game zone, it was built apparently as a non-standard structure to evade regulatory requirements, and the inquiry would reveal whether it was qualified to be used as an assembly building. So it is yet to be confirmed with the inquiry result whether it was qualified to be used as an assembly building. And we saw what is an assembly building, having a capacity of 50 people minimum, and they are here for amusement and purposes of the like nature. Now that we've seen and have had a look at some of the regulatory measures in place, in the state of Gujarat particularly. Now let's see how has the courts seen neglects on part of, let's say, building owners in the past so far as fire accidents are concerned. So here, I'm sure all of us are aware of the absolute unfortunate Upahar cinema tragedy of 1997. So let's talk about that. Among the most high-profile deadly fire accidents that have led to the loss of life, the Upahar cinema tragedy of 1997 in Delhi, it resulted in the conviction of the owners of the venue, the Ansal brothers, Sushil Ansal and Gopal Ansal, among others, for negligence and tampering with evidence. The death of 59 people, that's a huge number. So, the death of 59 people who were trapped in the balcony of the hall because of illegally installed seats and a blocked exit, it resulted in a protracted legal battle with the families of the victim eventually forming an association to seek justice. So, it was a very long, sort of a legal battle. The Upahar case, it was prosecuted with the charge of causing death by negligence, which is section 304A of the IPC, hurt and grievous hurt by rash or negligent act, 337 and 338 of the IPC, by the owners of the cinema, and culpable homicide, section 304, and other sections in the case of theatre staff and public agency employees, such as the Electricity Authority. Now, why are we talking about the Electricity Authority here? Because the transformer of the Electricity Authority, it was placed without sanction and allowed without safeguards. It was thought to have triggered the inferno. The owners had to directly bear the responsibility for the willful structural deviations. Essentially, the court held the owners of the property, the employees and the staff from the electricity agency liable for devastating toll in the Upahar tragedy, for violating the law so far as the fire safety norms are concerned, and thereby amounting to a negligent act leading to death, and also later for payment of compensation. On June 13th last year, the anniversary of the blaze, the Association of Victims in the tragedy, they blamed the judiciary for allowing the Ansal brothers to walk out of jail on a reduced sentence. In the wake of this fire accident in Gujarat, the Gujarat High Court taking suo motu cognizance, it has led to scrutiny of the enforcement of fire and building laws on the one hand, and the identification of several unauthorized venues in the state hosting leisure and entertainment services. The court was told by the Ahmedabad Municipal Corporation that a recent law, which is the Gujarat Regulation of Unauthorized Development Act of 2022, which is very recent, 2 years back, it came in force on 2nd of Jan last year. It was used by an unauthorized game zone to apply for regularization. Gujarat has witnessed more than one terrible fire in recent years, and if we have a look at some of the data, that will do shortly. So this is the figure. But for now, if you remember in 2019, a fire broke in a tuition center, which led to the death of 20 students. That was also very devastating. So that was another incident of these buildings flouting these norms. After Rajkot, the Gujarat High Court took note of the public interest litigation before it, and the court also noted that insult had been added to injury. Now, why was this remark made by the court? This was because its earlier orders had not been complied with by the state government. The suo motu notice issued by the Gujarat High Court, it extends its directions on fire safety, and it calls for a government report on action to comply with the comprehensive development control regulations, fire NOCs, periodic checks under the Fire Safety Act, and issuance of licenses under various acts. Earlier, the state government had informed the court that nearly 163 hospitals and 348 schools in municipality jurisdictions did not have a valid fire NOC. So this is the picture. There are nearly 163 hospitals and a massive number of 348 schools in the municipality. They did not have a valid fire NOC. Schools, hospitals, these are absolute essential institutions. Hospitals where you have patients who may not be in a capacity to run for their life if emergency happens. And so is the situation with schools where children at such young age who do not possess the absolute maturity to escape an accident. So that's a very sad state of affair, at the least so. It cited practical difficulties and lack of trained manpower and infrastructure to achieve full compliance. Given that there were 241 fires in commercial buildings and 42 in government buildings in 2022 alone, killing a total of 257 people. This is a data which was released by the NCRB. Tightening the implementation of the provisions of building code and the model building bylaws, it is absolute imperative, absolute necessity. Full accountability by the state and enforcement agency, it is vital. Temporary and ramshackle structures which are allowed to come up in urban and rural areas, attracting unwary leisure seekers, run the risk of setting off deadly fires. They need to be tightly regulated for safety. So with this, we come to an end of DNA. Thank you so much for watching. Have a wonderful weekend ahead.